Thank you so much for joining us today for the Fifth Circuit social media ruling, a conversation with FCC Commissioner Brendan Carr and Daphne Keller. You'll see that I am not Michael McConnell. I'm Morgan Weiland. I'm the Executive Director of the Constitutional Law Center, and I will be standing in his large shoes moderating the event today. But I'm delighted to welcome our two speakers to talk about the Fifth Circuit's opinion and what the consequences might be for the First Amendment and the future of online speech. So briefly to introduce them both in the order in which they'll speak. Commissioner Brendan Carr is the senior Republican on the Federal Communications Commission, and he served previously as the agency's general counsel. Before he joined the agency as a staffer in 2012, he worked as an attorney for Wiley Rein LLP in the firm's appellate litigation and telecom practices. Daphne Keller is the director of program on platform regulation at the Stanford Cyber Policy Center. Her work focuses on platform regulation and internet users' rights. Previously, she was the director of intermediary liability at Stanford Center for Internet and Society up until 2020. And then before that, she served as associate general counsel for Google. So I think we're in excellent hands with these two, and I will turn it over to Commissioner Carr for his opening remarks.
Oh, thanks so much, Morgan, and thanks so much to Stanford for hosting this event. I very much look forward to the discussion, and hopefully we have a back and forth. And if there's questions from folks that are watching this, then happy to do that as well. I think this is an exceptionally interesting area of First Amendment law. And I think it's an area where, reasonable people can reach different conclusions. But I think it's important to have a sort of robust debate about the First Amendment. Stepping back for a second, I do think we're at an interesting point in time in the, generally speaking, free speech debate in this country. I think there's a strong component, including in some Supreme Court cases, that talk about the values and the benefits of a robust exchange of views. Of allowing room for dissenting religious views, dissenting scientific views, dissenting political views. And I think the reason, and I'll get more into the law later, but I think the reason for that is that's sort of core to how we solve problems in this country, is we have this debate, we have a public debate, we look at an issue from all sorts of different sides, and through that debate, good ideas, bad ideas, we come to solutions to some of our most pressing problems. I think it's important that we encourage that. There are negative consequences that come from that. There are bad ideas that get thrown out there. But in the main, I think we are far, far better off to have that robust exchange of views than to not have it. And I think, again, if you look at Supreme Court case law, there's a lot of support for this concept of there being a government interest in promoting speech. Whether you look at Turner itself, where it talks about the public having access to a multiplicity of information sources is a government purpose of the highest order, for it promotes values central to the First Amendment. And, for my part, I've been, very active on a lot of these content moderation cases and debates in this country. Florida obviously has its own social media law that has been blocked by the 11th Circuit. We now have the case that we're talking about here, the Fifth Circuit case that comes out of the Texas social media law, which in the main has two core components that are dealt with in the decision. One effectively is a set of disclosure, transparency, complaint process provisions. And the second, I think sort of the one that raises the most interesting First Amendment issues, has to do with the prohibition on nation against viewpoints. And I think for a lot of people, and I am someone that is a Republican and a conservative, I start from the idea that a private entity, a private corporation, has the right not to have people on their property, speech on their property, carry goods and services, that is the starting point. And I think the debate on the First Amendment side with respect to this issue, which is, can federal or state governments regulate the right of a social media company to not carry certain speech, has been a bit impoverished up to now. in part because I think the debate has largely appeared to start and stop with one Supreme Court case, which is an important one, Miami Herald versus Tornillo, which every person with interest in the First Amendment or that has suffered through law school is very familiar with, but it's largely a case about a Florida law that would have forced a newspaper to run effectively, editorials, political editorials that they didn't want to. And a lot of the debate about whether federal and state legislatures can limit the right of a social media company to not carry certain tweets in the Twitter circumstances or not tends to start and stop with, well, you can't make a newspaper carry an editorial, and therefore, by necessity, you cannot make a social media company carry a tweet, for instance, that it doesn't want to. And obviously, that has a lot of sort of logical appeal to it, but it only is looking at a certain portion of the Supreme Court's First Amendment jurisprudence when it comes to, again, that core question of whether you can regulate that right to exclude. And we have a number of really important Supreme Court cases that we can run through that are discussed at length in the Fifth Circuit's decision and ends up being fundamentally, I think, the component of the Fifth Circuit's decision. And while it is true that on the one hand, you have Miami Herald, which says you can't require a newspaper to run editorials, there is a whole continuum of what you could call cases that intrude on the traditional right to exclude that come out all sorts of different ways. And so to say that there's never a circumstance where the government can lawfully regulate the right to exclude is not true and is not consistent with Supreme Court cases. So for instance, I think some of the core cases that the Fifth Circuit grapples with, and I think comes out correctly on, you have Miami Herald, Pruneyard, PG&E, Turner, Hurley, Rumsfeld. And I think if you look at all of these Supreme Court, whether you call them compelled speech cases or you call them regulation of the traditional right to exclude cases, you can effectively put them on a continuum. And when you look at these cases, and I'll try to do it briefly, you can identify 3 to 6 factors that the court implicitly or explicitly is looking at those cases that determine whether in that circumstance, the government can lawfully regulate that traditional right to exclude. And so if you start, for instance, with Miami Herald, that is a case that is essentially a forced speech case like the Fairness Doctrine. That's what the Fifth Circuit case talked about. And so as I walk through these cases, I think it's important to keep a couple of factors in mind. One, for instance, does the case involve you being forced to use your speech or your creative or expressive activity to carry a particular message? Another factor I think you can see in these cases is, are you being forced to associate with speech such that other people will attribute that view or that content to you? Is the regulation itself triggered by the content of speech? Does it operate as a prior restraint? And is the medium that is being regulated, is the entity there constantly exercising editorial discretion and artistic expression and speaking in their own voice? Or does the medium look like something that operates as a conduit for other people's speech? And I think you can look at some market factors as well. But as I quickly run through some of these cases, I think if you look at those factors, you'll see that they are more or less present in these cases, and that underneath of these cases is what's driving the outcomes in them. So again, Miami Herald, that's a newspaper. And unlike, I would say, Twitter or Facebook, the issue in the Fifth Circuit case, every single letter that is printed by the Miami Herald is the Miami Herald's own speech. It is never operating in the main as a conduit for other people's speech. And when you force it to speak, you are necessarily using the Miami Herald's own voice. Again, contra that to Twitter, where if you're not allowed to take a tweet down, it is not forcing Twitter in its own voice, the @Twitter handle, to carry any speech at all. And so again, I think when you look at some of those core values that I've talked about before and how they apply to Miami Herald, it can explain why Miami Herald comes out the way it does and why the Fifth Circuit case comes out differently. Similarly, Pruneyard, right? That 1980 case, it's a case where students were distributing or wanted to distribute pamphlets at a private shopping mall, seeking support for their opposition to a UN resolution. Again, you would traditionally start with this idea that, well, it's a private mall. They can control who comes and goes. They can eject people at their will. But that case doesn't turn out that way. It says no. And the court says that, requiring a mall, which again, different from a newspaper in terms of the people that are coming in there, it's not forcing the mall to speak. It's not sufficiently associating that petitioning activity with the mall itself. There's no penalty on the mall's speech, and there's no requirement that the mall reply to it. So again, I think if you look at some of these underlying factors, that helps to explain why Pruneyard comes out the way it does, and why Pruneyard is an example of the general rule that a private entity has the right to exclude, not bearing out in that particular case. I think PG&E is another interesting case. This is a case that's often cited by people that want to strike down these restrictions on discrimination by social media companies. But again, the analogy there was to a newsletter, which again puts it much more in the main like a Miami Herald newspaper case. It basically talked about it, the opinion, as if these bill inserts were like a small newspaper. And also that the requirement was triggered by the government wanting a particular message, an opposition message to PG&E to get out there, and that there be a forced association with the speech. Another interesting case that I've talked about that the Fifth Circuit decision walks through as well is Turner. And I think this is a really interesting case. So Turner has to do with a set of rules that Congress passed in the 1990s dealing with cable companies. And again, you would traditionally start with this idea that a cable company is a private company and they can pick and choose what channels to carry. But that's a case where the Supreme Court said no, Congress can lawfully regulate the cable company's decision about what speech to carry or not. And I think the reason for that, again, is that cable operates in the main as a conduit for other people's speech. So again, unlike Miami Herald, it's not a case where cable company is programming all of the speech that goes across it. And again, there's no direct association between the speech on a cable channel and being the speech of the cable company itself. Hurley is another interesting case. Again, Hurley is a case that's cited by people oftentimes are looking to strike down these regulations on limiting censorship by social media companies. Hurley's a parade case, and I think that's a case that looks a lot more like a composer, like a newspaper, that there is necessarily very particular selection of expressive activity that's going down. You don't think of a parade as organized in that case as principally representing a conduit for other people's expressive activity. There's an intimate connection between the messages there and the parade itself. And this is, again, something that the Fifth Circuit decision walks through. And then finally, Rumsfeld, which is a case about not sending money to schools that discriminate against military recruiters. And again, there, as the Fifth Circuit describes that case, I think rightfully, it talks about not forcing schools to speak in their own voice. So again, I think when you look at these, and there's others, whether you want to call them compelled speech cases, or you want to call them cases that involve the regulation of the traditional right to exclude, they come down in different places. Sometimes the regulator is allowed to do it, sometimes they're not. But I think as the Fifth Circuit decision walks through in all of this, you can see a pattern emerging, which is these core factors that are present. And I think unlike a newspaper, a lot of social media, Twitter, Facebook, operates in the main as a conduit for other people's speech. Now, one thing the Fifth Circuit does say is the Fifth Circuit appears to say that the actual act of censorship, of taking a tweet down or moderating content, is itself not a First Amendment expressive activity at all. That doesn't even really trigger the First Amendment. It views it more as conduct. And I think even if you don't reach that view, even if you take the position that censoring and taking down tweets is itself expressive activity protected by the First Amendment, I still think you reach the same result ultimately as the court and the Fifth Circuit did, again, for all the factors and reasons that I just walked through. I'll also say this about the Fifth Circuit case. It was a facial challenge, which is a fairly high bar to meet as a general matter. You basically have to show that there is no potential lawful application of the statute in any circumstance. And also, I think one interesting case about all of these sort of content moderation cases that touch on 230 is there's a provision in 230 F3, I believe, that basically says if you are contributing, even in part, to the message being delivered, then you fall outside of Section 230 protections, which means as to Twitter's own speech, Twitter is not protected by Section 230. And so I think part of the interesting wrinkle in these cases is that if you as Twitter, I'm just using that because it's easy to reference, really bear hug this idea that your censorship is imbued with your expressive views, there is a risk that in doing so, because of the structure of 230, that you arguably walk yourself out of Section 230 protection. So there may be a reason statutorily why social media companies can't quite make the same full-throated argument about censorship being imbued with expressive First Amendment values, the way that you saw, for instance, again, in the Miami Herald case. But stepping back, and I'll end my filibuster at this point. Again, I think the general idea that you can't force someone to carry speech or associate at all with ideas they don't want is right as a starting point, is right as a general matter, but it's not right in every case. And you can look at the Supreme Court's compelled speech cases, and I think Miami Herald sort of sets the outer edge on one hand, and there's this string of other cases based on the presence or absence of particular factors, including, are you operating as a conduit in the main or your own speech? Are you naturally and necessarily associated with the speech or not? And you can then put across this spectrum all of these cases that we just talked about. Perhaps on this far other extreme end was one of the DC Circuit's 2017 net neutrality cases that said net neutrality rules as applied to ISPs, in the court's view, didn't even really trigger First Amendment scrutiny. Of all those cases, I think Turner is probably the best rough analogy for what we're seeing here in the Fifth Circuit case, but it's not, directly on point per se. So with that, I'll take a breather break, and then step back in a little bit.
Great. I guess I will pick up from here. So I'm very happy to talk about the case law, especially Hurley. But I will hold that for the discussion later, because I think that works better as a back and forth. I want to start by saying that I do think there are First Amendment interests on all sides in this case. There are speaker First Amendment interests, there are platform First Amendment interests. I think if you add up the precedent, the platform should clearly win. I wrote about that in a case called Who Do You Sue that goes through the same cases that Commissioner Carr just talked about. But I also think that precedent is about to change, so it doesn't necessarily matter how I think those cases add up or can be sort of fit into a coherent narrative. I do think this is a good time, precisely because the precedent might be about to change, to talk about what we should want here, and whether there is a doctrinal way of getting to an outcome that is coherent and rights protective and wise as a policy matter, and all these things that we want to see in the world. There's a huge wave of new platform regulation happening all over the world, including the ones in Texas and Florida. And it's happening for a reason, because we have enormous platforms, including my former employer, who have unprecedented power over speech. Ordinary speech that one day would once have been shared in a bar or a church or a note passed in class or in a newspaper or in a private letter is centralized in the hands of very, very few players. And those players have a capacity to monitor and control that speech, at least crudely, to a degree that no one has ever had before. Particular images can be caused to disappear the instant that they are posted. Particular phrases can be caused to disappear. And then lastly, that power is in private hands. It's this power that humanity has never seen before, and it's in private hands, and it's not constrained by the First Amendment or the Fourth Amendment. So people who are worried about censorship or surveillance, I think, have reason to be thinking about whether the laws should change. So one response to all of that concentrated power is to say, that's too much power, let's decentralize it. Let's use competition law or give more autonomy to users, maybe do that using privacy rights of users or rights to set preferences for content. But around the world and here in the US, we're seeing a lot of what I think Texas and Florida did, which is lawmakers saying, oh, this centralized power over speech is terrible. In order to protect our citizens, we, the government, are going to have to take that power for ourselves, and we'll tell the platforms how to use it in a responsible way. We will tell them what speech to carry. We'll tell them what their users, meaning you and me and our moms and our kids and our second grade teachers, what all of us are going to unavoidably have to see if we log on to Facebook and Twitter. The Texas and Florida laws were sold as a way of getting rid of censorship. And I'm going to talk a little bit first about why, even if they were that, that's not what these lawmakers' constituents actually want. And secondly, why that's not actually what they are, why elements of these laws at least layer on lawmakers' own preferences about speech rather than the common carriage that is invoked in some parts of the laws. The starting point here is that Americans are often very unrealistic, including lawyers are often very unrealistic about what speech the First Amendment permits. It permits all kinds of terrible stuff: graphic violence, virulently racist hate speech, pro-suicide content, pro-anorexia content, barely legal harassment, all of this bad stuff. And for the most part, that is held in check in normal life by norms, people's moral sense of responsibility, and similarly, platforms are keeping it in check, either because of their own morals, norms, sense of responsibility, or because market forces told them to have those morals, norms, and senses of responsibility. But the law permits that to be there. And in a world with no censorship, where platforms didn't take down any lawful speech, that's the stuff we would be seeing all the time. I think the failure to recognize just how much lawful but awful speech is out there really distorts analysis of platform law on the left and the right. So on the left, you get people imagining or outright claiming that if Congress took away platforms' immunity under CDA 230, then the platforms would have to take down hate speech, which of course is not the case. In fact, when the New York Times said this, they had to run a correction that said, quote, "The law that protects hate speech is the First Amendment, not Section 230, unquote." And my point isn't that that could never change or that there's never an instance where hate speech is unlawful under current law. My point is that if you assume that a bunch of stuff is illegal when actually it's First Amendment protected, then your whole expectations about how changing 230 will change the online discourse are going to be off. On the right, you get a similar distortion, which is what I think happened in Texas and Florida, where politicians don't realize what all this stuff is that they are trying to unleash on their constituents. The content that I described before, I won't go through that list again because I'm about to go through another terrible list. So the Texas and Florida laws are not quite unleashing the freedom from censorship that their drafters proclaimed themselves to be enacting. They're a little bit different in a way that arguably is better. It's better than the fire hose of garbage that I just described, but it also isn't a sort of content neutral support for speech that the Fifth Circuit and the lawmakers made it out to be. So in Florida, which was not the case in the Fifth Circuit, but in Florida, the rule would be that anyone who registers to run for office can post any of those horrible things that I just listed, as long as it's not obscenity. There's a carve out just for that. And also anyone who meets a very broad definition of journalism can post that stuff. In Texas, the rule is that platforms can moderate, but they have to be viewpoint neutral. What viewpoint neutral means is not defined, but I think it has to include parallel treatment for differing viewpoints on some topics like, here comes the ugly list, whether the Holocaust happened, whether some races are superior to other races, whether the Oklahoma City bombing was an act of terrorism or an act of heroism. There is an endless list of things that get talked about on the internet for which permitting viewpoints on both sides would change the experience of ordinary users in a way that I don't think these lawmakers anticipated or intended. So in Texas, the lawmakers also couldn't help throwing in some policy preferences of their own, so that theirs are not speaker-based the way that the Florida law is. Instead, they have some categories of speech that platforms can take down regardless of its viewpoint. So generally, no takedown. You have to be even-handed across viewpoints, but there's a carve out for a couple of things that are both really awful, and it's understandable why the lawmakers wanted to give special disfavor, special legal disfavor to these categories of speech. One is a set of lawful but awful speech relating to violence and racism, which is spelled out in a standard that kind of looks like Brandenburg, but is not Brandenburg. And the second is any speech that is the subject of a referral from an organization that aims to prevent sexual exploitation of children and protect survivors from ongoing harassment. That's definitely not one of our established First Amendment carve-outs. So we have the lawmakers of Florida, again, understandably, saying we're going to pick winners and losers between different kinds of lawful, but in this case, very awful speech. The Fifth Circuit managed to uphold this law in part, I think, by ignoring this very problem. It said at one point that platforms had an obsession with terrorists and Nazis, as if taking down speech by, about, and in support of terrorists and Nazis were not something that platforms do every single day, and that would be imperiled or perhaps prohibited by the law that Texas just passed and that the Fifth Circuit is upholding. And the court's analysis, I think, really depends on this pretense or hope that the First Amendment or Texas or Florida's law, Texas's law, allows some distinction between lawful but awful Nazi speech, which the platforms can still take down, and lawful but politically important speech that the platforms now have to leave up. That's the kind of distinction that we may, in some cases, make in these sort of like para First Amendment realms, like communications regulation, where there is a First Amendment reason upheld by the court to treat a medium differently and give it, somewhat different rules than we would have in a bar or a park or other places. But it's not something that the court has given us reason to think that the legislature of Texas can create. And so I'm not sure if this goes to the Supreme Court, what do they say? Do they say, yes, let's uphold this law and unleash these sort of tides of garbage on Texas? Or yes, as a esteemed colleague suggested to me last week, we're going to strike those carve-outs because those carve-outs make it content-based. So like you no longer have a carve-out for this Brandenburg-esque standard or the sexual abuse survivors standard, and now it's content neutral and we're going to uphold it. Or is there instead some direction of the sort that the Fifth Circuit seems to imagine, which is like, yes-ish, we will unleash some of the tide of garbage, but not the worst of it. We're setting a whole new standard for online speech. And by the way, that standard is going to affect you and me and your mom and your kids and that whole list from before. That would be wild, but I don't really understand what the outcome of this case can be and what world we live in if it's not one of those things. So I'll stop there.
Well, I thank you both Sorry, I'm late getting here. My internet, I'm in a rural location and it's really quite terrible. So I'd like to turn to Brendan and ask if you let's be very brief because mostly these are conversations with the audience. So maybe 2 or 3 minutes of response to what Daphne has just said.
Well, thank you, Judge. Great to see you. As someone that works at the FCC, I apologize for the poor internet service in rural America, but we are working on it. We're trying to improve it throughout. I would say I think there's a couple of what I would describe as sort of largely false choices that are presented in this debate. Again, I sort of walk through one at the front end, which is to say either the government can never regulate the private right to exclude, and that's sort of case over. I think that's not the case. Obviously, we have a lot of cases from Pruneyard to Turner to the net neutrality case where judges have said, no, there are appropriate circumstances in which the government can intrude upon and otherwise regulate the right to exclude. And I think that done the right way, I think you can certainly go too far. I don't think the government itself, for instance, should be picking the tweets that stay up or stay down. But I do think we can put some pro-speech guardrails in place that protect political speech in the main. I think the other sort of false choice that's often presented is that we either are going to be deluged with terrorist content, or if we do any regulation in the space, or we have to leave the status quo alone. And again, I think we can do better than that. For instance, I think that we could put, again, these pro-speech guardrails in place that in the main are protecting, dissenting political, scientific, religious speech. And you can be very explicit about terrorist content not being protected, profanity even not being protected. There's a whole slew of, as Daphne put it, lawful but awful speech that you can craft regulation of this that doesn't necessarily compel it. And the other thing is, again, this speech does not have to be viewed. And that's one of the beauties of how social media operates. You can not follow someone on Twitter. You can block someone. I don't block anybody, if people are wondering. You can mute people on Twitter. And so the idea isn't necessarily that I don't want to hear this speech. I think when pushed to its extreme, it's that the idea should not be allowed to exist or be heard, even among consenting people, which I think sort of pushes it too far. But again, in the main, I think the idea is in the appropriate circumstances, you can regulate the right of a private party to exclude goods or even in some cases speech. And I think this is one of those cases where we can do that appropriately.
Thank you. Let me put this to you, Daphne. We heard these various cases that Brendan talked about and that the Fifth Circuit discussed can be seen as analogies. None of them are exactly the same as social media, but they're all, fruitful analogies to help us figure out what matters and what doesn't. Here's a different analogy. There's a whole branch of free speech law, which is public forum doctrine. This is where people have a right to, or are given a right in a certain type of public forum. They're given a right to speak on government property using government resources. And in that context, the government has pretty wide discretion to regulate on the basis of content of the speech, but not viewpoint. Might that be an analogy? Because the social media are kind of like public forums. They're not government property, but they are kind of like public forums. And might it be possible to have a First Amendment doctrine which allows fairly reasonable regulation of content, thus getting at that lawful but awful speech, but without allowing viewpoint discrimination?
So first, I 100% agree with you about analogies. And I think that's one of the things that's really frustrating in this area, because of course, platforms aren't newspapers, and also they're not phone companies. And, there's a reason that in many areas, we actually want different rules for them because they're in a different space. There's a woman named Heather Whitney who wrote a pretty good article for the Knight Foundation about the issues with analogies in this space. And actually in Denver area, which prefigures basically every fight we're having now. And by the way, has Clarence Thomas on the opposite side from the side that he's on now. There's also the justices there are fighting about what's a good analogy and should you use analogies and what is the function of an analogy. So there's a very rich vein there. I am not sure that public forum doctrine gets us to where we want to be. I think because of the same issues about viewpoint discrimination, the sort of was the Oklahoma City bombing a good idea, to be celebrated or a bad idea. I'm not sure that you get away from those problems. I also think, well, let me back up and talk a little bit about some of the points that Commissioner Carr made. Just a super technical point, I think if you use social media platforms and you only ever see content from people you follow, you are indeed protected from a lot of this, but you are also missing out on a very large portion of what the function, the sort of discovery function or expansion of knowledge function that they would otherwise be serving. I'm interested in the idea of, well, maybe interested in a bad way, of putting pro-speech guardrails in place for speech on the biggest platforms. Again, because that would mean the government is newly picking winners and losers among what was previously all legal speech, not by platforms, but by internet users. And that's very much what the UK is going through paroxysms trying to do with the UK online safety bill. And it's been kind of nightmarish for them, trying to figure out, well, what are the new rules of speech that used to be legal, but now the law says platforms have to take it down? Who administers those rules? Can users appeal a takedown under these new legally mandatory rules and get the kind of due process that A, they are due under the Constitution, but B, helps us clarify what the rules actually are and move from sort of statutory words on the paper into the richness that case law gives us in understanding what we can and cannot say. I don't think that the FCC has sufficient staffing to become the agency that hears all of those millions or billions of appeals, but I could be wrong. And so I don't see a great way forward that lies in defining this new category of speech that can or should be censored by platforms, but used to be lawful. I am a big fan of an alternate way forward, which is to say, instead of having the government dictate new rules for what gets said on platforms, you try to devolve more power in the system out to the margins, out to the users, out to competitors through things like what our colleague here at Stanford, Francis Fukuyama, has called middleware, the idea that you can go on Facebook and then choose a content moderation or ranking lens that comes from a competitor of Facebook. So the ESPN flavor of Facebook or the Disney flavor of YouTube or a version of Twitter that is curated by a Black Lives Matter affiliated group. I feel like there are a whole lot of ways that we can experiment with diversifying the sort of multiplicity and plurality and noise of what people encounter online before putting the government in charge of it.
I do think, just real quick on that, there may be an interesting point of agreement there, which is, I've talked about this idea of user empowerment, which is, if you look at 230, one of the ideas it talks about there was creating incentives for then websites, now platforms, to give users tools to do their own content moderation. I think one criticism that I have is I think that hasn't been as necessarily as robust as it could be, in the sense that I think we've seen a centralization of content moderation by the platforms themselves. Whereas I think one way out of this for everybody could be to say, look, if you want MSNBC to filter your feed, here's a plugin, do that. If you want Fox News to filter your feed, do it. But if we could decentralize that content moderation from the companies and put the power back in people's hands, that could be an interesting way forward that might, work for everybody.
I totally agree about that part of 230. And I think there's a really interesting chicken egg question of like, would we have gotten these user-controlled technologies, browser plugins or whatever, if the platforms hadn't come along and centralized that function? Or is it actually so hard to build, good user-controlled content moderation that we got stuck with it centralized in the hands of platforms? But whatever the answer was in the years of evolution we've already gone through, there can be a different answer now because the technological possibilities keep changing.
Let's turn now to some questions from the audience. I'd like to remind everyone listening to put your questions into the chat. And Morgan has been following the ones that have been coming in, and we'll pitch them to one of our speakers or the other or both.
Great, thanks, Michael. We're so glad you were able to join us. We're happy that you're here. We won't get too mad at the FCC for the problem. So speaking of Commissioner Carr, actually, this question is for you. Why isn't the Texas law preempted by 230?
Well, the Fifth Circuit decision obviously sort of walks through how its read of Section 230 reinforces the outcome there. And I think, when I think about Section 230, as I sort of read it, I know people that are reasonable disagree with me on this, but I in the main think that the right way to think about it is to say that, Section 230 C1, gives a platform protections for leaving speech up. And I think that's a great thing. I think 230 C1 makes a ton of sense. I think it is a pro-speech provision. And then when it comes to, in my view, Section 230 C2, which should, in my view, be read as what are the protections you have for taking speech down? I think in the main, courts have sort of effectively read that provision out of the law, as I read it, and instead said you have carte blanche to take speech down, whether it fits in one of the enumerated C2 categories or not. And so I do think that state legislatures, whether it's Florida or Texas or others, can step in and delineate, what can be discriminated or not discriminated against in a way that does not run afoul of Section 230 itself.
I think it's interesting. It's a fascinating question, the sort of like nested boxes of what work is the First Amendment doing and what work is 230 doing, and how do they intersect? If I recall correctly, and I might be wrong on this, I think this is something that Florida raises in their cert petition, saying, oh no, all of the problems that have been described here won't happen because those are preempted by 230, more or less. I'm overstating that, but I think they sort of invoke 230 as a reason why the law doesn't have the consequences that the platforms are saying. But if that's the case, and Commissioner Carr, following your analysis, if we say that courts are wrong about C1 being a basis for a defense in must carry cases, then it seems like Florida and Texas could have just drafted a law that says we're creating a cause of action for removal in bad faith of non-objection content, right? Like you could delete pages and pages of legislative text and just arrive at the thing that on your reading is not carved out of 230.
Yeah, no, I do think in the main, I do think, labeling something as a bad faith takedown, as disagreeable as that outcome may be to some, it's sort of how you deal with Section 230 and not preempting those state law efforts.
So to continue on the 230 theme, how would you both connect your views about the Texas law to the issue in Google v. Gonzalez? And just for the edification of our audience, this is a case where the court just granted cert, and the issue is whether 230 C1 of CDA immunizes interactive computer services, or the Twitters and Facebooks of the world, when they make targeted recommendations of information provided by another information content provider, or if it only limits the liability of these services when they engage in traditional editorial functions like deciding whether to display or withdraw content with regard to such information. And I'll share a link to the SCOTUS blog.
Yeah, I think this is going to be a really interesting set of cases, two taken up at the same time on this issue, which is to say, when is a platform engaging in conduct that falls outside of the 230 protection? Some of this goes to what I was talking about with Section 230 F3. If you were sort of algorithmically picking and choosing and deciding what material to display to somebody, is that the same type of thing that Congress meant in the 1990s that is protected, or is that a different type of conduct that falls outside of 230 protections? I think that's has potential to be a pretty sweeping decision from the court, but we'll see which way it goes.
So my Cassandra cred in this area is excellent. I'm now 2 for 2. Well, if they take cert on net choice, I'm 2 for 2 on the last things I wrote about becoming Supreme Court cases. So the last major piece I published was called Amplification and Its Discontents, and it takes on the First Amendment version of this question, which I think is closely linked to the 230 version of this question. And what I would say is that platforms are engaging in speech through their editorial choices and their, as Eugene Volokh has argued, their ranking choices. And the speech is the selection and arrangement, in the same way that we grant different copyrights for selection and arrangement on the one hand, and the underlying works that have been selected and arranged on the other. They both are deemed expressive enough to get copyrights. The message of a Google web search query is, I think this is what you're looking for. The message of your Facebook feed is something pretty boring, like, I think this will make you happy and make you stick around and keep clicking. But there's a message being expressed through the ranking and also through the moderation rules. So like, we're going to take down Nazis, or whatever the rules may be. That is not the same as the platforms adopting responsibility for the user speech that they have selected and arranged. It could be, I think if you believe that something about the moderation process or the algorithmic ranking process gives the platforms the ability to recognize illegal content and do a good job of taking it down, then maybe that's the moment when you want to get rid of 230 and say, okay, platforms, we're giving you the responsibility to do this. But for now, I think that we have heaps of evidence. I can talk about this if people are interested. They're terrible at it. They do not have a good means to figure out what's illegal that somehow arises through the process of ranking. And so I don't think it's reasonable to say through the process of ranking, they have now somehow adopted and taken on liability for the user posts, the tweets in your newsfeed. And this is particularly relevant in, Tomna, which is the companion case to Gonzalez that is going up. And that one's on the merits of the Anti-Terrorism Act claim instead of on the 230 question. So in Tomna, the question would be, do platforms have knowledge, which is the scienter standard for that statute, based on this algorithmic ranking? And I think they clearly don't. So I think it is not hard to see a speech element that belongs to the platforms in the ranking and selection and moderation without making the included user posts become their speech.
Thanks to you both for that. Switching gears from 230, a couple of questions from the audience that touch on First Amendment issues. So this one's for you, Commissioner Carr. One of our audience members notes that you argued that Twitter can't reasonably be associated with the speech that it hosts. And then he points out that Disney's former CEO recently explained that the company contemplated buying Twitter, but ultimately decided not to because of, quote, all of the hate speech. Advertisers have long pressured social media to moderate content they don't want their ads associated with. And this person is now asking you, aren't these clear market indicators that social media services are in fact associated with the speech that they host, much like traditional media?
I think the question from the First Amendment perspective is it associated in the way of Miami Herald? Is it associated in the way as Pruneyard would have been, as Rumsfeld would have been? It's not necessarily that someone making a decision to purchase the company believes that there's association. It's sort of a separate objective inquiry from there. Again, I think when you look at Miami Herald, traditionally newspapers are running things that has their stamp of approval and their backing, and there's virtually no daylight that you would perceive between the content that a newspaper is running and the newspaper itself. I think you can juxtapose that with Twitter, which is to say, every tweet that somebody says is not sort of intimately associated with Twitter the same way running something in a newspaper would be. Same like people going to a mall. Same with the UN resolution that was at issue in the Rumsfeld case. It's not necessarily that someone think I don't want to buy this because there's an association there. It's sort of a separate, First Amendment inquiry of a degree of association. And then again, association, in my view, is one of several. Maybe there's 4 or 5 or 6 factors you can look at. So maybe there is a higher association, someone would believe, than what I think when it comes to a tweet. But then again, you have to look at the other factors, which is it operating, in the main as a conduit for other people's speech? Are you allowed to have your own voice at Twitter, the actual Twitter handle, speak unimpeded as compared to these other content moderation regulations that we're talking about?
Unless you wanted to weigh in, Daphne, I'll move on to the next question. Okay. Another First Amendment based question, one of our audience members points out that in the Fifth Circuit's opinion, they really talk a lot about the First Amendment's original scope, which this audience member thinks is characterized as being primarily concerned with prior restraint and matters of public importance. Do you, either of you, think the current Supreme Court will pick up this originalist thread? And if so, would that put a lot of other First Amendment case law at risk?
Well, for my part, I'll say this, again, and this goes back to my point, whereas I think the Fifth Circuit, it's a really good decision. I like it. I think it effectively indicates that content moderation, at least in the Twitter context, is not itself speech. It puts it more on the conduct side of the line. I would say, even if you view it as speech, even if you view it as, First Amendment protected activity, which I think is not quite clear that that's what the Fifth Circuit did. But even if you do, so if you don't want to go so far as to say it's not protected by the First Amendment, it is still capable of lawful regulation in the First Amendment sense. So I don't think you have to go that far or necessarily get 5 Supreme Court justices to say content moderation is itself conduct and not First Amendment protected speech to uphold the Texas social media law against a First Amendment challenge.
I do not pretend to have a real prediction about the answer to this question. If I did, I would be making a lot more money. I'm actually very curious what Michael thinks the answer is. But I will note that the sort of connecting that up to the question about algorithmic ranking and Gonzalez, the case that the court is hearing, I don't think anyone in the generation of the founders would have said newspapers have a right to print articles, but not to organize them. The idea that arranging things is not editorial conduct or editorial discretion or choice just strikes me as very strange. And no matter what era you look at, you run into a version of that problem. Maybe connecting that a little bit with the Miami Herald discussion from before and the question about when a platform or a conduit for third-party speech has associated itself with the user speech, with the third-party speech. I think you can play with the facts there so much that you can come out with any answer, right? Because in Miami Herald, they could have said, oh, well, this is going to be printed in a box that is clearly labeled not the Miami Herald speech. And so that makes it not associated. There's just a lot of room to solve the problem about being compelled to carry speech you don't want to by putting a label on it. And then finally, I promised I would get back to Hurley. I think Hurley is the strongest case for the platforms here, because that was a case where the parade operator had not selected anything very carefully. I don't think it was very much like a musical composition. The parade operator had barely ever even excluded anyone before, but then it found out that there was a gay rights organization in the parade and said, wait, I want to exclude them. And the court said, that's fine. This is a message that the parade operator didn't want to be associated with, and they have a right to exclude speech. But if that's enough, if that's the thing that gives you a First Amendment right here, clearly platforms are doing much, much more than that. They're crafting far more extensive editorial policies, excluding far more different kinds of speech. So I think Hurley helps the platforms quite a bit.
Yeah. And I do think, again, I think the representations matter. I think when these websites in the main, they don't hold themselves out as conduits to the same extent that ISPs do. But I still think that that is relevant. So for instance, I think you could have, a smaller bespoke website that says, look, we have viewpoint X and we want to push viewpoint X. And I would say that my view of the First Amendment is that their hand is strengthened in that type of a case as compared to Twitter and Facebook, such that the type of regulations that I'm talking about for Facebook and Twitter would not survive First Amendment scrutiny as to that smaller website that has a clearly defined viewpoint that they're expressing. But in the main, Facebook and Twitter say, for all the content moderation that we do not discriminate on political viewpoints. And so I think that would inform a First Amendment case where the law at issue is one that is about protecting political viewpoints. Now, if these websites say, look, we want to be family friendly, and you have a law that says you absolutely cannot be family friendly, again, I think that's a more difficult case than a case we're talking about, as I would like to see more protections for diversity of political viewpoints.
I do think there's an interesting varied question here about which platforms we're talking about. So the Fifth Circuit said every platform that's covered by this law is represented by the plaintiff trade organizations here, which I think is definitely not true. I think there's a very long list of probably Quora is covered and probably Glassdoor and probably Etsy, and my understanding from Eric Goldman's blog citing some of the briefing is that this is because Texas told the court that the only platforms in scope were Twitter and Facebook and YouTube. And so there's an interesting question. I'm interested in your answer, Commissioner Carr, about how far down the size threshold or the market share threshold should a law like this go in taking away editorial discretion from smaller platforms?
It's a good question. And I think this is one where you need more specific, to survive First Amendment scrutiny, I think it aids to have legislative findings that would be sort of deferential, given deference by the court. And a lot of people look at the arguments that I say and they say, well, look at the Colorado cake baker case, and your position necessarily means that you got to bake that cake in those cases. How do you square that with sort of, traditional conservative thinking on that type of case? And again, I say it's similar to what we're talking about right here, which is if you're a single Colorado baker that has a viewpoint, that's very different than if you're a nationwide, massive platform. And so I think, to your point, the platform matters, the size of it matters, market power, I think, matters. The value to political discourse matters. How much you've said that I'm going to lean in on a political viewpoint or not matters. And again, I think all of that, in my view, puts Twitter and Facebook in a vastly different realm for First Amendment analysis than if you're applying something similar to, a single Colorado bakery or a website version of that.
which is going to the court, right? We have the Colorado baker back in the form of a website. So
so my sort of theory, people can disagree with it, is would support a finding that the Colorado cake baker has a First Amendment right, if that's the constitutional claim there, to not bake a particular cake. But my theory would also allow for Twitter and Facebook to not have that discretion when it comes to political viewpoints based on market and other factors that I've sort of walked through.
And Brendan, is that because of size, or is that because of how they have held them? I think it's held themselves out.
Yeah, I think it's a couple factors. It's how you hold yourself out. I think it's the centrality of the thing, the bakery. How central is the bakery to sort of political discourse in 2022 versus how central is, a Facebook or Twitter to sort of First Amendment interested political discourse, right? That's where politicians are. It's where journalists are. It's where academics are. Scale, generally, you basically have to be on Twitter and Facebook today, essentially, to be really relevant and persuasive in a political discourse. Do you have to have a particular baker in a particular town make a particular cake? I think there's a lot more substitutable options there for you than you have when it comes to Facebook and Twitter for participating in political discourse?
Well, I see the time is up. It went by so quickly. I really appreciate and know that the audience does. If we were in person, I would be leading the audience in applause for our two speakers. Thank you very much, Daphne Keller. Thank you very much, Brendan Carr, for being with us this evening. And I thank the audience too for attending and for all your excellent questions. I would like to remind you of the some of our upcoming events. Next Tuesday on that's October 25th, Russ Feingold and his co-author Peter Prindeville, a Stanford Law alum, are going to be doing a constitutional conversation based upon their book about constitutional amendments and what's needed in order to preserve American democracy. And then on Friday, the 28th, we're having our Supreme Court annual Supreme Court roundup with Lisa Blatt from Williams and Connolly, Aaron Murphy from Clement and Murphy, and our own Pamela Carlin. That's always one of the great events of the year. And so I look forward to seeing people there. And those are both in person. So we actually will see one another. And again, thank you very much, Commissioner Carr. Thank you, Daphne. And good evening to everyone.
Thank you. I really appreciate it. Thank you.
Thank you.